Good afternoon, ladies and gentlemen, and thank you for joining us this afternoon. I'd also like to thank the Institute for inviting us today and for their support in organising this series of CPD events. So just by way of introduction, my name is Ir2 I'm Business Development Manager in Harvest Financial Services. And this is the fourth in a series of CPD webinars we've held with the Institute over the last number of months, where we've looked at a number of aspects related to retirement planning and pensions. So over the last few months, we've looked at property investments through pensions and both the investment rationale for investing in property and the different ways of getting exposure to property, be it through funds or direct property purchase, and the tax efficiencies of doing so through the pensions. We then moved on to look at the specifics of self-administered schemes and some of the key client considerations in relation to funding, investments, planning for liquidity, and longevity in retirement. And this tied then into the third session, in which we looked at the various tax reliefs available to business owners at retirement. And we focused on tax efficient ways to extract profits from businesses to build your own personal wealth, and how these funds might be invested to grow personal wealth in retirement. And one of the key considerations through each of these presentations was the impending changes to pensions legislation, which will directly impact on individuals' retirement plans. So we're delighted to be joined today by Stephen Gillick and Patrick O'Connor of Mason Hayes Curran, who are going to look at some of the proposed changes and how they will impact scheme trustees and members. Just before I introduce Stephen and Patrick, I just want to cover a couple of housekeeping issues. We'd invite you to ask any questions during the presentation, and the question box should be at the bottom of your screen, and we'll address all questions at the end of the presentation. Just also as part of the Institute's wellness programme, Virtual Health for a Virtual World, they've asked us to take a minute break during the presentation. So we'll do this just before Patrick joins us later. So without further delay, I just want to introduce our two speakers today. Patrick O'Connor joined Mason Hayes Curran in 2019, having previously worked as an in-house solicitor with a large pension provider and professional trustee company. Patrick advises trustees, pension providers and employers on all aspects of pension law, including drafting and amendment of scheme documentation and interpretation of pensions legislation and revenue compliance. So Patrick is a council member of the Association of Pension Lawyers in Ireland and of the IAPF Investment Committee. So Patrick will join us after our first speaker, Stephen Gillick. Stephen is partner and head of pensions in Mason Hayes Curran and has extensive experience advising trustees, sponsoring employers and pension providers on a range of issues, including pension scheme establishment and restructuring, pension specific data privacy advice, pension scheme funding and de-risking exercises. So Stephen is a member of several industry bodies and sits on the Pensions Council, that is the statutory body that advises the Minister for Employment Affairs and Social Protection on matters relating to policy. So I think we're in good hands this afternoon, and I'd invite you to sit back, enjoy the presentations, and I'll join you for the question and answer session at the end. Thank you.
Thanks, Emer, for that introduction. And thanks a million to the Institute Chartered Accountants and indeed Harvest for asking us to provide this talk today on just a legal update on pensions in Ireland. And I'm going to take this presentation from the viewpoint that you may not be familiar with the legal position of pensions and how pensions are legislated for in Ireland. So this is really going to be a ladybird guide. The slides contain more detail than I intend to go into today, but they could be used as a useful reference point going forward. If we look at pensions, sorry, just have it back here. We're going to split the talk into 4 sections. I'm going to cover the first 2 sections, and then Patrick, Senior Associate in the MHC team, will cover the second. The first 2 sections that I'll deal with will be on the Ir2 Directive for trustees. So that's a key piece of pensions legislation that's been coming down the line, and it's been coming down the line for a long period of time. The second area I'm going to look at will be relevant, hopefully, to a lot of individuals on this webinar. It concerns trustee responsibilities. So this will set out trustees, the basic structure of a pension scheme in Ireland and what trustees are expected to do from a legal standpoint. The third section of the talk after our 1 minute break will be a discussion really between lay and professional trusteeship. So Patrick will discuss how the industry is really moving towards a more professional trustee than the previous position, which had been essentially people who worked in a company taking the role of trustee of pension schemes. And then Patrick will wrap up the talk by going through the recommendations of a recent report from the Interdepartmental Pensions Reform and Taxation Group. So the first piece I want to look at is the Ir2 Directive for Trustees. Now, Ir2, it sounds like some sort of droid or something from Star Wars, but it's a piece of European legislation that it has been delayed for a long, long time. It should have been in place 2 years ago. Because if we look at it from the legal position of pensions in Ireland, pensions are really regulated by relatively recent case legislation. The key piece of pensions legislation in Ireland is the Pensions Act 1990. So if you look at it, the legislation is about 30 odd years old. Prior to that, a lot of pensions was really governed by the Trustee Act 1893. So as you can understand, regulating pensions from a legislative viewpoint is only relatively new. So the Ir2 Directive is a new piece of European legislation that seeks to harmonise pensions across Europe. Now, it provides for a lot of different aspects, some of which we'll discuss during the next few minutes. The first directive, Ir1, was really the first step between harmonisation of pension schemes across Europe. And it kind of opened the gate, as it were, for a pan-European pension scheme, which is a large issue in pensions because it's often difficult, and Brexit has complicated this once again, for individuals to move their pension from country to country. So, and as the employment relationship has become more fractured, for instance, if we look at lots of multinationals, individuals may come to Ireland, work for 2-3 years, then travel to Europe. So the value of a pension and paying into it for 2 years when they won't have access to it until they retire, and even then, where in the world will they be when they retire, and what will be the taxation consequences of that? So that needed a bit of work, and Ir1 kind of set us on a route towards a more kind of harmonised position across Europe. Ir2 seeks to improve that position further by making pensions more pan-European and for enabling individuals to access their pension and pay into pensions across Europe. Now, it has a lot of other changes that we'll go into, and I suppose the key take home is Ir2 is going to make pensions more heavily regulated in Ireland. So it's got a lot of provisions in there for trustees. There are several provisions that are useful. For instance, you're going to look at a standardized members benefit statement. So at the moment, a members benefit statement, so the yearly piece of paper that a lot of pension scheme members get and file away and never read, the contents are dictated by the Pensions Act. So presumably the Pensions Act is going to be updated when Ir2 comes in. Now, I should say Ir2, I did indicate earlier that it's been delayed. So basically how Ir2 is going to kick in Ireland is that the Irish state is going to have to implement its own legislation to give effect to the European Directive. We should have done that over 2 years ago, and we haven't for various reasons. So we're subject to fines due to the delay, and there's constant kickbacks. So the latest obviously is COVID, that this has delayed the legislation, and there was also an interesting High Court challenge to it that is actually relevant because Ir1 impacted on all pension schemes apart from small single member schemes. So they were exempt from the provisions of Ir1. Ir2, the understanding is that it will apply across the board. So there will be no exemptions for single member schemes. So this may affect things coming down the road. For instance, single member schemes may in the future have to have various different assets. So they can't hold one asset class or one asset, whereas previously under Ir1, single member schemes could, to a certain extent, do what they wanted in terms of investment. That may change when IR2 comes in, but we don't know because we're waiting 2 years for the legislation to bring it in, and we haven't actually seen any draft legislation. So, as I said, this slide goes into a bit more details. The second bullet point is the important one, really. The Ir2 Directive provides for EU-wide pension scheme standards, including fit and proper standards for trustees. Now, Patrick is going to go into this, well, not the Ir2 Directive provisions, but the distinction between lay and professional trustees, because there was a feeling in the industry that more professionalism needed to come into the role of trustee. Not that the trustee needed to be a corporate professional trustee, but that the days of a trustee with limited knowledge of pension schemes controlling assets worth millions and millions were over. So the Ir2 Directive aims to more heavily regulate the role of trustees. There's going to be a lot more policies as well in relation to internal audit, relevant actuarial and outsource activities. So in essence, this is going to make pensions more expensive because more policies will be needed to be put in place. More oversight will be required in relation to those policies. So IR2 is going to make the provision of pensions in Ireland that bit more complicated. Now, the Pensions Authority has focused on IR2 and no doubt has been feeding into the draft legislation, hopefully, that we'll see. So it will be interesting to see what extent IR2 and the legislation implementing it will change the position. Trustee boards are obviously going to come under a lot more scrutiny going forward. So if any of the audience today is a trustee of a pension scheme, I think the key take home from your perspective will be that IR2 is going to make the regulation of pension schemes that bit more onerous in terms of time and tasks to be done. And also for those individuals that have personal pension schemes, just going forward, IR2 may change the landscape, especially if an exemption in relation to single member schemes is exempted. But once again, that is up in the air because I know there was lobbying by the industry to have single member schemes and smaller schemes exempted from what I've seen are onerous provisions of IR2 that would make the operation of smaller schemes more expensive and not really economically viable for providers to run. So there's question marks out there in relation to IR2, how it will come in and what exactly it's going to do for pensions in Ireland. The third bullet point here is in relation to trustees' fit and proper requirements. So the individuals, as I said, typically trustees appointed in Ireland may have been individuals, certainly with some knowledge of finance and figures, and a lot of accountants would be trustees of pension schemes of their employers. But you're looking at that changing. You're looking at the role of trustee in the future definitely becoming more professional, with more onus on training, more onus on trustees possibly holding certain qualifications of a certain level. So the whole role of trustee will change in the next 2 to 3 years. So if any of the audience today is a trustee of a pension scheme or has been asked to be a trustee, it's just something to be aware of, that the role of trustee is certainly becoming more onerous and more professional with more responsibilities. And IR2 is certainly going to reinforce that position. A lot of IR2 was the focus was on risk management, and that trustees and pension schemes were aware of the risks that schemes faced, be it investment loss risk, risks that the assets may not match the liabilities, especially in defined benefit schemes. So own risk assessments, ORAs, they'll have to be assessed in relation to each scheme and specify the risks that the scheme faces or may face. I'm going to look a little bit now and just step away from IR2 in relation to trustee responsibilities. So as I said, a pension scheme, the role of trustee, if we look at pension schemes in Ireland, total Ladybird guide, they're essentially split between defined contribution and defined benefit. Defined benefit schemes are the ones that we regularly read about in the newspapers. So they're the ones that can run a deficit. And there's about, I think last call, about 500 or so schemes left, defined benefit schemes, but they hold a massive load of assets. So they're still very, very important to the pensions industry. Defined contribution is certainly the way forward. It's a typical scheme where you'd have an employer and employee contribution. Those contributions together with investment return will hopefully provide a pot of money at retirement with which the member can buy benefits. So whether that's an annuity, which are very expensive, or possibly an ARF. And Patrick will discuss ARFs somewhat more later on. So you can see here, being a trustee of a pension scheme, be it a DB or a DC scheme, is pretty onerous. I mean, they have to ensure the contributions are received, so that the employer takes the contributions from an employee's pay packet and has to remit those to the trustees within 21 days. And you've had several cases taken by the Pensions Authority where employers have essentially taken contributions from employees and not remitted them. It was mainly back from the financial crash in 08-09 and primarily focused on the construction industry, where some employers were simply using the pension contributions to stay afloat rather than to provide pension benefits. Trustees have to invest funds, so typically most trustees take professional advice in relation to the investment, and there's an investment manager appointed, but the trustees of a pension scheme would obviously have a responsibility in relation to the investment and what investment choices are provided to members. To make arrangements for paying benefits, that differs in DB, DC, to ensure that records are kept. This is more onerous these days than it was due to our good friend, which everyone is aware of all too much, GDPR. So a lot of trustees are questioning, what records do we need to retain? How long do we need to retain them? In relation to individuals, a lot of pension schemes are getting subject access requests, and they are very expensive and labor intensive to conduct. So it's something that trustees are more conscious of these days, that records are kept, and they're not kept for periods that are either too long or too short, or that the information that they're keeping isn't excessive. Trustees have to undertake trustee training, and this typically involves a course, and trustees have to, an individual trustee has to do the training when they're appointed to a scheme, or every 3 years once they're appointed. And there's various tools. I think the Pensions Authority has an online program that you can actually complete, but the thing takes maybe a day to complete, because if you tick the wrong box and get a question wrong, you get spit out and have to return to the start. So, and some of the questions are tricky enough, but it's more onerous. I mean, there's a trustee training undertaking, and that will certainly get more onerous going forward. Registered administrator, I don't intend to go into that. So a trustee owes a duty of care. I mean, this is the legal point. I mean, the trustees are there. Their responsibility is to look after members' benefits. So they have to act in a way that is in the members' best financial interests. So if a trustee is ever going to get sued, it's no doubt going to come from a member that thinks an action they took in some way jeopardized or reduced their benefits. So they have a duty to act with prudence and the scheme documentation. So the trustee of a pension scheme sets out the trustee's responsibility, but this has been layered upon by case law, both UK and Ireland over the years. So trustees would, if you're a trustee of a scheme, you certainly need to know what's in the trustee rules. Certainly the provisions that set out trustees' discretionary powers. I'll go into a little more detail later on about one of those, that's the payment of debt benefits. But the trustees would need to know what's in the trustee rules, and they need to have a copy of it somewhere. So at retirement from a typical scheme, the main benefits that are paid out of the scheme is is in relation, it's either a transfer value. So an individual typically can request that their pot of money, the transfer payment, is paid out to the scheme in relation to pension just in order. Trustees would also, as I discussed earlier, they have a lot of discretion in relation to debt and service benefits. And it's important to note that the payment of a transfer value on the first point there is often dependent on what type of scheme. So is it a defined benefit scheme? Is it a defined contribution scheme? If it's a defined benefit scheme, there are certain implications in relation to the funding level of that scheme and the ability to actually take a transfer value out of it. And then often in the last few years, we've seen a lot of schemes have what are risk reduction exercises, essentially, where the employer has offered the individuals a transfer value from the scheme. So if you're a member of a defined benefit schemes, a lot of the banks have actually operated these, whereby they would say you can take a pot of money. Say if your pot was $500,000, they'll offer an enhancement, maybe 5%. 10%, so they'd offer, say, perhaps 650,000. The individual could take that, but by doing that, they would cease participation in the defined benefit scheme. So it cuts off the risk from the employer's perspective that they don't have to continually fund the DB scheme, which is more risky from a financial point of view than a defined contribution scheme, but they do have to pay the employee a certain enhancement. So there's a lot of ETV, as they're called, ETV exercises recently, and trustees would have to pay careful attention where one of those is issued. Trustees aren't on this on their own. The final point here, the trustees, every trustee that I've ever seen has the power to delegate. So as I mentioned before, a scheme would have professional advisors such as actuaries in a defined benefit scheme, investment managers, administrators to help with actual day-to-day provisions, day-to-day bits of work to do in the scheme. But the trustees have to be aware that overall responsibility rests with them. So I'd always advise a trustee to make sure that the trustee rules contains an indemnity. So the indemnity would provide that if they do make a mistake in the running of the scheme, that the employer essentially picks up the bill, and the only really exposure for the trustee will be in relation to fraud, if they do conduct fraud while they're acting as trustee of the scheme. The one thing I would flag is an indemnity is only as good as how strong the employer is. So if the employer doesn't have the funds to actually back up the indemnity, you're in trouble. So a lot of trustees may also seek professional indemnity insurance as well before they actually become a trustee of the scheme. One of the well, interesting is one way of describing it, I suppose, but onerous as well. Will be trustees deciding in relation to debt and service benefits. So a lot of pension schemes, be it defined contribution or defined benefit, provide a debt and service lump sum, typically 4 times. But once again, we're seeing a lot of schemes, asking members whether they want to substitute a spousal pension for a higher debt and service lump sum. And there's obviously tax implications for that, but some of the debt and service lump sums will be 10, 15 times salary in exchange for removing the spousal pension. It's something we're seeing a lot more. So debt and service, typically the trustee has a discretion there as to who gets this benefit. And where there's a discretion, there's also an argument often, because there's scope in a lot of the payment of debt and service benefits for trouble, be it the payment is to an individual. For instance, a lot of the payments are dictated by what's known as a letter of wishes. So it's essentially a letter where the individual writes to the HR department that says, if I die, I'd like my pension lump sum or debt and service lump sum paid in X proportion to these lists of individuals. And they're often problematic because sometimes there is none, or sometimes the letter of wishes is drafted and it predates either a marriage or several children, and the trustees are left in a sticky situation as to whether they stick with the letter of wishes or would they change, bearing in mind that they think that it's actually being passed out by events in the deceased's life. So there's a lot of issues in relation to the payment of debt and service benefits. Trustees, I generally advise when they're paying a lump sum that they have to consider all facts. I mean, where trustees will get into issues is if they make a knee-jerk decision, decide that the ex-wife or the ex-husband will get the lump sum, that's it. Decide that basically over a 10-minute Zoom call and don't really investigate it. Every single debt and service payment requires full investigation of the facts, because it's only through asking questions that you realize that what was a simple, relatively simple circumstances may be more complicated. So it's certainly something that we advise on from time to time. Another thing from a legal perspective and the role of trustees that's quite problematic is conflicts of interest. Patrick will discuss the lay distinction between lay trustees and professional trustees in more detail later. But typically, you'd have a pension scheme, and all the larger schemes may have a trust set up under trust. So the principal employer will be the employer, responsible primarily for paying the contributions to the scheme. And then the trustees will be typically 3 to 4 individuals that work in the company itself. And there's obviously potential for conflict there. For instance, if you are in the CFO position, let's say, of the company, and you're also the trustee of the scheme, the company may be making decisions such as winding up or closing the scheme to future accrual that will affect the pension scheme, and you know, and you glean knowledge by virtue of your position in the company on this. So it's something that needs to be carefully managed. I do think there's a role for individuals from the company itself acting as trustees of the scheme, but they need to be aware how to identify and manage conflicts of interest, because they can be managed. I mean, the nuclear option is to resign as a trustee if a potential conflict is identified, but there are other ways of managing a conflict, such as abstaining from votes, identifying, logging the conflict, and taking a view that your position with the employer doesn't affect your ability to make a decision that will be in the best interests of the members. So just an important point for individuals to remember: conflicts of interest. Trustee decision making. I mean, as I said earlier, key provisions are in the trustees and rules. Once all relevant factors have been considered, it's very hard to actually challenge a decision made by the trustees. The members may not like it, but if all essential factors have been considered, it makes a challenge more difficult. Trustees have to take appropriate advice. Of course, as a solicitor, I will say that, but it is important that the trustees' decisions are minuted, and that where they do require to go to a third party, be it an accountant, for instance. Often we see forensic accountants brought in, where I do regularly involve with the accountancy business will be where an employer is saying, listen, we can't, to the trustees, we can't afford to pay into the scheme anymore. And trusts and accountants are often brought in to actually examine, is that correct? And have a look at the books of the employer and have a forensic analysis to see if if it is correct that the employer cannot pay the contributions. Identify any conflicts of interest. As I said, very important that they're identified. There's always a way to manage them. Nuclear option, resigning, but lots of other ways that we can actually do that. And to ensure that a decision is taken is in the best interest of the beneficiaries. So that's the key element for trustees, that they need to actually look at every decision. Are we taking this wearing our employer hat? If you are, you're opening yourself to challenge it. Whereas if you're using your trustee hat and you're taking a decision, then it often is very difficult to challenge if you are acting in the best interests of the beneficiaries. So now, as Emer mentioned, we'll be able to take the 1 minute break. So the talk will recommence in 1 minute with my colleague, Patrick O'Connor. Thanks for listening.
Hi, everyone. Thanks, Stephen, for that. So as Stephen said, I'm going to move through two main areas. I'm going to look at lay and professional trusteeship, the differences between the two, and take a look at the corporate trustee as well. So when a company is incorporated for the purposes of carrying out the duties of a pension scheme trustee. As well as that, then I'm going to look at some recent recommendations of the Interdepartmental Pensions Reform and Taxation Group on single member schemes, also known as third pillar vehicles, and just go through some of the recommendations, which are broadly good for the aim of which is to simplify the single member space, both pre and post retirement. So looking at the current status of occupational pension scheme trusteeship, you can have individuals as trustee, be it lay or professional, so individuals who qualify as professional trustees. You can have a corporate acting as a sole trustee, where it's a nominee company established by the sponsoring employer or by the sponsoring employers group. Or of course, you can hire a professional trustee company as well to do that work for the scheme. Often you see a mix nowadays of lay trustees, might be officers in the sponsoring employer, CFOs or COOs, together with a professional trustee acting in tandem as trustees. Given the potential exposure to personal liability that there is, and just the volume and complexity of pensions legislation that we've seen over the last 10 or 15 years, there has been a move to professional trusteeship. And certainly the Pensions Authority has sort of been nudging towards highlighting the benefits of professional trusteeship as well over the last couple of years in preparation for implementation of IR2. So where a company is appointed as trustee, the directors of the company will fulfill the duties, the board of directors of the company will fulfill the duties of the trustee. The advantages of having a corporate as trustee over an individual are that removing or appointing a trustee or a member of the board of directors is easy. You hold your meeting, you pass your resolution, you file your B form, and that's it. Whereas with individuals, you're preparing deeds of removal and appointment, things like that. In terms of execution of scheme documentation, it's easier as well. You don't have multiple individuals executing, you just simply have the professional trustee company or the nominee company executing as usual, two directors or one director and a company secretary, and the application of the company seal, or and according to the company's constitution. What are the disadvantages? There's more paperwork and administration. So if a group sets up a nominee company to act as trustee to its scheme, you'll have your annual returns, filing your financial statements, and dealing with all the filings throughout the year. So you may have to nominate or instruct a law firm or a corporate governance firm to carry out that work. As well as that, transparency might be an issue for the employer, where all the decisions in respect of the scheme are being taken place at board level in a different company, in a nominee company. Cost is potentially an issue there as well, certainly where you have a professional trustee company. And conflicts of interest as well, certainly possible where you have, you'll have the same directors acting as directors of the nominee company as you do the sponsoring employer. So that can be an issue there. Looking then in more detail at the professional trustee, as I said earlier, it can be an individual or a corporate. It has become a common choice in recent years, simply because it's their day-to-day. They have the skill and industry experience. Pension trusteeship is what they do. Where they're independent of the sponsor, where it's a professional trustee company, that does help to avoid conflicts of interest arising. And the trustee training requirement as well, probably not that big a deal, but the employer does have to arrange trustee training for lay trustees, whereas for professional trustees, that's something that they need to look after themselves, and the obligation isn't on the employer. Disadvantages of professional trustee, of course, are costs. They'll charge an annual fee for their service, and then typically will charge fees for ad hoc work on a time basis as well. So the cost is probably the bigger issue still for appointing a professional trustee. Lay trustees, just considering some of the advantages and disadvantages of what the lay trustee is, they will know the company very well in the workforce. So as I said, typically a lay trustee will be a senior officer in the company. They will know the company very well. They'll know the staff very well. They can often act as a useful link between the members and the trustee board, i.e. the members of the scheme. and of course, it's more cost effective. The disadvantage is lack of experience and knowledge of pensions law. I mean, why would anyone who is newly appointed as a lay trustee have, detailed knowledge of pensions law or regulation when they're appointed? And it is quite a steep learning curve nowadays. There is the potential for conflict of interest. So if you imagine a senior officer in the company is appointed as trustee and they're also a member of the scheme. So when it comes to bigger decisions, then the conflict will need to be managed. As Stephen said earlier, it might be abstaining or it might be simply declaring the conflict as well. But the conflict has to be managed according to Pensions Authority guidelines. Also, as I said earlier, the employer must maintain trustee training for lay trustees. Broadly speaking, is there still a place for the lay trustee? Well, we have a raft of regulation now that trustees will need to get their heads around. GDPR, of course, ever-changing revenue rules and tax law. And I put in there the EU Supplementary Pension Rights Regulations 2019, which are, I put them in there as an example of just very nebulous regulations that no one saw coming in 2019 and that are a little bit controversial and quite difficult to understand. The purpose of the regulations is good. It's to facilitate further facilitate the free movement of workers across the internal market, but there's a lot to understanding a regulation like that. And then Ir2 and the Pensions Authority. The Pensions Authority has certainly pushed for trustees to review their own boards, ensured that every 3 years to ensure that they have the necessary, they can commit the necessary time and attention to the position, and that they have the necessary expertise and experience as well. So you can definitely see the Pensions Authority sort of pushing towards and nudging the industry towards professional trusteeship as well. And of course, finally, then the increasing popularity of third-party vehicles, which we'll look at briefly shortly, particularly the PRSA over the last decade, and other vehicles as well. It's the PRSA is particularly flexible in terms of, if you're likely to move employment often, as people are so likely to do nowadays. So is there still a place for the lay trustee? I think for now, yes, but I think in time we will eventually see the lay trustee phased out. So I'm going to move on then to my next topic, which is, as I said, the report of the Interdepartmental Pensions Reform and Taxation Group. I'm just going to refer to them as a group for the purposes of the rest of the presentation. The aim of their report is to suggest possible reforms to third pillar vehicles, single member pension schemes. It's chaired by the Department of Finance and it has representatives from Revenue and the Pensions Authority as well. If we look at the PRSA, so the PRSA is a contractual arrangement, so it's not set up under irrevocable trust, and it was established in 2002. It didn't prove very popular initially, but over the last decade, you can see the figures there. It has really proved to be a very popular pension product. So by third quarter 2020, we had almost 368,000 PRSAs with a total asset value of over 7.5 billion. One of the biggest recommendations of the group's report is the replacement of the Approved Retirement Fund, or the ARF, which is to be replaced with a redesigned whole of life PRSA. So the object here is to simplify the post-retirement pensions marketplace. So instead of an approved retirement fund and an approved minimum retirement fund, which I'll speak about very shortly, you'll just have a PRSA in retirement. Instead of your annuity option, you'll select your PRSA option. And for PRSAs, there's currently a requirement where you can't draw down from the age of 75 onwards. That the group has also recommended the removal of that. So that would actually, it would make what's known as the vested PRSAs, the PRSA that you carry into retirement, identical to what is currently an approved retirement fund. So the approved retirement fund would then be abolished and would just have a whole of life PRSA. And as I've said there, that it potentially provides an appropriate destination for automatic enrolment savings. So if someone finishes employment and they're looking to transfer their automatic enrolment savings to a new vehicle, and let's say they're going to consultancy themselves, they'll simply move into their PRSA, see out their careers, with that PRSA and then retain that all the way through retirement. Of course, the concept of drawdown from a PRSA in retirement already exists, as I said, in the form of the vested PRSA. So at the end of the ARF, the group has suggested that it will advance technical proposals. So we haven't drilled down into the detail yet. I mean, we've gotten very broad recommendations from the group in the report, but they haven't drilled down into detail. They've also recommended the abolishing of the approved minimum retirement fund, which goes hand in hand with the ARF. Probably won't come as a surprise to many because it's seen as redundant. I mean, currently, to where you have, if you choose the ARF option instead of your annuity, and your income level is going to be below 12,700 euros per annum, then you have to set up an approved minimum retirement fund as well. However, with the state pension at the level that it's currently at, the approved minimum retirement fund isn't a requirement for most people who choose the ARF option. So they've recommended the abolishing of that. Also, the report has recommended a reform of the tax treatment of ARF assets on death, and we'll get into that very shortly in the next couple of slides. They've also suggested an increased regulatory focus on pensions drawdown and the need to take financial advice in retirement. The concern is that financial advice is always taken pre-retirement at the point, perhaps when someone is purchasing the ARF from the ARF provider. But then perhaps they'll turn around and say, well, look, I'm fine now, I don't need to take any further advice in retirement. But there's a lot of risk of assets being utilized too quickly and too early in retirement. And that's still a concern. So the need to provide financial advice all the way through retirement with the whole of life PRSA or the ARF was a focus of the report as well. So the recommended treatment of the ARF for inheritance tax purposes, the report noted that currently the ARF represents tax relief funds, which are also allowed to accumulate again on a tax-free basis. And of course, you have that rule where, depending on the age of the child that's inheriting an ARF, they either pay CAT or income tax. And this, the group sees as a disincentive to ARF drawdown retirement, and it's undermining what's known as the exempt taxation regime. So it's of the view that that should be amended to ensure that both income tax and capital acquisitions tax apply to ARFs where proceeds are inherited by a child. I think it's really, they noted that the ARF was being used as an estate planning device and a wealth planning tool more than it was as providing benefits in retirement. And that's the concern, that it's not being used as maybe initially what the initial intention of the legislation was that created the ARF. So the group's also recommended the cessation of the buyout bond on a prospective basis, as well as a retirement annuity contract. The buyout bond is a policy that you can transfer your pension to if you leave an occupational pension scheme. Retirement annuity contract, or RAC, is the formal name for what's known as a personal pension. Again, it's an insurance contract approved by revenue and offered typically by, and I think only actually by life companies. The report instead recommends that a redesigned PRSA will be utilised to facilitate the runoff of buyout bonds and retirement annuity contracts. Again, the overall aim is here simplifying the number of third-party vehicles that are available. So removing those and removing the ARF as well, it'll simplify it. I mean, at the moment, for any consumer, looking at the pre and post-retirement vehicles available in the single member space, it is quite confusing. There's a lot to take in. It's also recommended that buyout bond and RAC savers may wish to transfer it to redesigned PRSA to cater for certain buyout bond and RAC characteristics. So this would be another potentially different type of PRSA that's redesigned to take into account elements of the buyout bond or the retirement annuity contract, just the life assurance elements. The report is also kind of linked to this. It's also suggested the end of the 15-year rule. So currently, a member of an occupational pension scheme with more than 15 years service has two transfer options. They can transfer to another occupational pension scheme or to a buyout bond. So if the buyout bond is to cease on a prospective basis, there would have to be an alternative then. You wouldn't have a buyout bond option at all. So the group has recommended that the PRSA should be allowed to take benefits from those leaving an occupational pension scheme where the BOB were to end. So if we didn't have the BOB or the buyout bond, we would have a PRSA in its place. It's also an interesting lump sum recommendation that it's made where buyout bond holders currently have access to 1.5 times salary or the ARF option on retirement. PRSA holders can only avail of the ARF option at present. So to continue facilitating that lump sum option or retirement, the report recommends that both options should apply to assets transferred from an occupational pension scheme to a PRSA, so that those assets would be ring-fenced in your PRSA, and you would still have your two options there, your 1.5 times salary or your ARF option, 25% tax-free. And then any other contributions that are made to the PRSA on top of that will be subject to just the one option, the 25% max lump sum. So I think that's it from me, and I believe I'm going to hand back to Emer now, and we're going to just take questions from the floor.
Thanks very much for that, Patrick. Stephen, I might just ask you to just join us again as well. There's a couple of questions in from the audience. So the first one is, are there firms where a scheme can access the services of a part-time professional trustee, or is it possible to have a part-time professional trustee?
Yeah, no is what I'd say. I've had this several times requested from clients. I think if you get it, there are certain individuals out there who have been trustees of various big pension schemes, and they're offering their services, but they generally have to be appointed as a trustee. So it's all or nothing. So either you appoint an individual to act as a trustee of the scheme, or you appoint a corporate trustee, or you take professional advice from actuaries, solicitors, accountants in relation to the scheme, and factor that into decisions. But there's not really a scope to appoint an individual on a part-time basis to be a trustee.
Okay, and what experience and qualifications would a professional trustee be expected to have?
Well, that will all change with IR2, I think. There is talk about certain standards and levels, and that will be specified in guidance from the Pensions Authority, that the individual is a fit and proper person. I mean, there are certain requirements in relation to convictions and the like, but that will change with IR2. So Pensions Authority is going to put up guidance on that at a later point. I don't know, Patrick, would you like to chip in there in relation to qualifications?
Yeah, I think the standards on the fit and proper side will be similar to what people working in financial services have on the control function requirements. I think it would be very similar. Otherwise, I think it's registering with the Pensions Authority and being registered as a pensioner trustee, and then adhering to the new requirements of the regulations when we have them in the directive. I think the Pensions Authority guidance, when it is published on the regulations, will answer a lot of questions. Well, we hope it will anyway.
Yeah, the regulator, and I mean, I think he's used this phrase often when he's asked about how the role of trustee is changing, excuse me, on pension schemes. He stated that he's not looking to professionalize trustees. So he's not looking to merely get solicitors, accountants, and professionals such as that act as trustees, but he's looking for the role of trustee to be more professional. So the individuals that act as trustees act in a more professional manner, seek advice, are more savvy in relation to their roles, their duties, whether they're under the legislation or whether they are gleaned from the trustee rules. So whilst we're not looking to, the industry isn't going to professionalize trustees at the moment, it's certainly looking for a more professional trustee. But then you've got pieces of legislation such as IR2, which are layering on regulation in relation to duties and responsibilities of trustee, and they certainly make being a trustee of a pension scheme more onerous than it was and than it has been in the past.
Okay, thanks. Now there's two questions here that I could probably take together. So if you bear with me while I ask you them, it's come in and it's in relation, Patrick, to the topic you were talking about for the interdepartmental pensions reform group. So regarding the report on replacing ARFs, will the former employer be able to operate a whole of life product throughout the former employee's retirement? So retirees don't need to go to the retail market. And what is the estimated timeline for these changes to come into law and operation?
Yeah, there isn't a timeline. We don't know. That's the reality. We don't know when implementation or how much of this will be implemented. They're still simply recommendations. What was the first part of the question again, Emer?
It was just will former employers be able to operate the whole of life product throughout the former employee's retirement? So retirees don't need to go to the retail market. And I actually have another question as well, just relating to that you might be able to answer the two together. And that's how concerned are employers and trustees of schemes about their obligations to employees at the point of retirement, following on from these recommendations?
We haven't seen much in terms of level of concern. Most people aren't familiar with the recommendations yet. If we do see them, yeah, I mean, the employer will continue to contribute up to the point that their employee retires. In retirement, then they'll continue on with that vehicle. It won't be accepting contributions, obviously, in retirement, but it'll simply take the place of an approved retirement fund. So they'll be able to draw down from it, invest, and this is, the emphasis that's being placed on post-retirement advice as well for products like this. So it will behave in a manner identical to approved retirement fund, but it's just that it is something that you can have, up to the point of retirement when you're still contributing as well, and you can take it all the way through then. Whereas obviously there won't be an employer involvement after you've retired.
Okay, and I suppose I know again they're very much just recommendations at this stage, but has there been any discussion about where that financial advice would come from? Would that be internal, or would that be external professionals?
Yeah, they haven't fleshed that out, but I would think external professionals certainly. I mean, looking at the QFA qualification and just taking required advice from a regulated financial advisor. Yeah, I think certainly it will be regulated advice. Your investments are regulated or unregulated, that's another question, but the advice that they're looking at, I think, would certainly be from a regulated financial advisor. Yeah.
And would there be any discussion? Has there been any discussion about who would pay for that advice? Would that be the employer? Would it be the pension scheme? Would that be the individual themselves? They
haven't drilled down on that. Interesting. I mean, yeah, I think certainly. I think post-retirement, again, there's not going to be involvement from the employer. So in terms of the requirement to take advice and paying for it in retirement, I think it will be the individual. Yeah.
Okay.
There's additional complexities there, Emer, that I'm seeing, even because some employers are taking a proactive approach on this, and as employees are approaching retirement, they're saying, listen, we're not going to throw you to the wolves when you turn 65. That in the lead up to that, we will put in place retirement courses, essentially to prepare you for the various facets of retirement, and one being financial well-being. Employers were sort of and are nervous in paying for financial advice. Are they in some way liable if that individual takes advice and goes off and does something absolutely crazy? So the lawyers are typically involved in drafting something that exonerates the employer of responsibility, but where a cost is involved, I'm seeing either the scheme sometimes is paying for it, whether that's through additional contributions from the employer, or the employer takes the view that if you want financial advice, you have to pay for it yourself. And I mean, it's often the best thing to do to actually pay for independent financial advice that isn't linked to the employer. And the employer has sometimes a difficulty in that they think that the provision of advice exposes them to, I suppose it's relevant to some sort of Bernie Madoff issues down the line. So it's just something employers are conscious of, and they want to do the best for their employees, but they often approach lawyers such as myself and Patrick wanting to do this with limited blowback for them, essentially.
Okay. It's just a final couple of questions here. Would you have any concerns about any future restrictions on backdating contributions to employer pension schemes, to company pension schemes? Have you heard, has there been any talk about the restrictions for backdating contributions in any of the group discussions?
Yeah, well, I suppose this time last year we were involved in just keeping up with the election manifestos. Well, it's just over a year ago, and seeing proposals in relation to limits and contributions and limits in relation to the overall fund that a pension scheme can hold. And certainly if you looked at Sinn Féin's, it wasn't very pleasant reading in terms of what a pension scheme could hold in terms of assets. And the cost of annuity, I mean, just means that you have to have a bigger fund to actually pay for a benefit. I would hope that in time that the limits and contributions increase, but I would fear that they will temporarily go the other way, perhaps. But generally, when they do that, when they decrease the overall fund limit, they do allow an individual to apply for a PFT, so a personal fund threshold, that would be higher than the SFT, the standard fund threshold. So there's typically a bit of flexibility there. But I haven't heard any talk, to answer the question really, in relation to a reduction in the SFT, and that certainly isn't something that Fianna Fáil generally do, or Fianna Fáil governments do. That said, things change very rapidly in terms of pensions, and you never know what could come down the tracks.
Okay, and then the final question here is the previous CPD events. I do think that they are available, and they were all recorded. So there's a question here: do you have access to those? So if you contact the institute, you should be able to get access to them. They were all recorded and I think available to get to a link. So I think we're just coming up to 3 o'clock now. I'd just like to thank Patrick and Stephen again for, I think that was a very informative presentation, and really got us all up to speed, I think, on a lot of the legal issues that we're all facing over the next number of years. Anyone who's involved in pensions, be it personally or through their company arrangements. I'd just like to thank you both, and thank Mason Hayes for your time today. I'd also like to thank the Chartered Accountants for hosting the series of CPD events, and we would hope to see you again soon. And to thank you all for your time today, and enjoy the rest of the sunshine. Hopefully it'll last into the weekend. Thank you.
Thanks, Emer.
Thank you.
Thanks.